Shima. Will counsel in 127038, State of Kansas versus Raymond Cherry, please come forward. Mr. Meharry, you may take the lectern whenever you wish, within reason.
Thank you, Your Honor. May it please the court, Peter Meharry for Raymond Cherry. I would request 3 minutes of my time for rebuttal, Your Honor.
3 minutes is granted.
Thank you. This case comes before the court on my client's appeal from his conviction for various counts, the most severe being a felony murder charge, which he was sentenced to a hard 25 sentence for. Those charges arose out of what we often say is a drug deal gone bad. The state alleged that my client, along with 2 other individuals, conspired to rob an individual, thought he was going to sell weed, but during that drug deal, things went south, a fight ensued, and the person who was trying to sell the weed was shot and killed. The state's theory was that my client was one of the 2 people that entered the apartment. There was a 3rd co-conspirator that was outside in a waiting bar. My client brought a defense of alibi. He testified that he was home on that day in question, as well as his wife, who testified to the same thing. So the question at trial was who more so than what. And in this case, we've raised several issues that we believe show that my client did not get a fair trial in this matter. First issue we've raised deals with statements the prosecutor made in closing arguments. The prosecutor repeatedly used the phrase, we know. As this court knows, this is kind of loaded language that this court has said you cannot use for various reasons. Number one, that it does imply that the prosecutor may know things that is not presented to the jury. Also brings kind of the weight and credibility of the state behind it and pushes the jury to just follow the state's lead instead of objectively reviewing the evidence for itself. As I said, the state used this language multiple times, and it dealt with what we believe are contested facts so that it was improper to do so. The state has noted couple of the times the we know language was used as a question as opposed to a statement. We don't believe that makes any difference. Whether or not you say, how do we know it was Joe because of this evidence is no different than saying we know it was Joe because of this evidence.
Wouldn't have made any difference if the prosecutor had said, how do you know that it was Mr. Cherry?
Maybe. I think there's a difference between saying you know and we know. And I think the court has said the problem with the we know language is kind of the state is including itself, giving its opinion, putting the weight of the state behind it.
And the reason I asked, that's the answer I thought you'd give. But it seems to me there's a difference when the we know is put in a question the way it is here, as opposed to we know, because then it is the weight of the, I'm not trying to change the law. We know it puts the weight of the state behind something that is a disputed fact. But here, when you say, how do we know? It doesn't seem to have the same punch. So why do you think it has the same punch?
I think it has the same punch because when you're using we, you're including yourself. We know, as opposed to, I think there's a difference with you.
One's a declaratory statement, the other's still a question. And that's what's hanging me up here.
And again, I think there is no difference in saying, how do we know because of A, B, and C versus we know because of A, B, and C. The prosecutor is still using that we know language that includes himself, includes the state. How do we know? Me, the state, all the police that investigated. How do we know this? Because of A, B, and C. So I don't think phrasing it as question mitigates the problems this court has noted with using that loaded language.
It's the answering the question, right? I mean, it's the question with we know coupled with the answer that makes it that powerful, is what I'm hearing you say.
I agree, and that, just as if you would make a statement, we know because of A, B, and C, it's because you're combining them, you're combining the weight of the state behind this evidence. And I think you're doing the same thing, even if you phrase it as a question. So I think regardless of how it was said here, whether or not it was a statement at times and a question at other, it is error and problematic because, as this court has said, it puts this weight of the state behind it. It implies maybe there's things that the state knows that wasn't presented to the jury and would push the jury to just accept what the state is saying.
Can I,
Another,
go ahead, sorry.
just to make sure I'm understanding what you're saying, is another way to say this is that we often say that we consider prosecutorial error in the context. We have to look at the whole context. And when you look at the whole context, essentially, under your view, what the prosecutor is doing is using that as a rhetorical device to say, I know this for these reasons. Is that?
I mean, I think the prosecutor is saying, we know this. And I know this as a representative of the state knows this. So it's putting everything, all the weight with the state behind this evidence, kind of propping up this evidence for the jury with the weight of the state. He didn't say, I know, but I think by saying we know, he is including himself when he's making those statements in front of a jury.
Just want to be clear as to what your claim actually is specifically. I think I counted 4 specific we know statements that you claim are error. Are there more than, and I can go through each one.
I think that is correct. The sites I have, there was a couple times on record 44, page 170, where he talks about we know from their testimony when he's talking about the co-conspirator testimony.
Yeah, so if you don't mind, I can just real quick walk through it. There's the we know from the testimony. Then there's the how do we know it was Ray Cherry, right?
Correct.
And then there's why do we know it was Ray Cherry?
Correct.
And then there's one other reason we know it was Ray Cherry.
Correct.
There aren't any other, you don't make other specific claims of error from other parts of the argument. Those are the 4 statements we have to evaluate.
That's correct.
Okay.
That's what I raised in the brief, and that's where I believe the state did err in using that, as I have said, loaded language.
That's helpful just to narrow the universe of what we're talking about.
Sure.
I just want to ask a quick question on the first one about the testimony regarding the convenience store.
Mm-hmm.
Prosecutor says, we know they went in, we know they bought cigars, we know what he was wearing. Our case law suggests that we know language can be used when the evidence is uncontroverted. Given the fact that there was video evidence that showed this exact sequence of events, was that really controverted?
I would argue it was. I think there's a difference between having evidence to support the statement and being uncontroverted. And here, my client, his defense was, I was home with my wife. Wasn't
right,
me.
But I'm sorry to interrupt, but this we know statement isn't about your client, right?
No, but it is about the co-defendants. And I think when you start saying, even if they have other evidence to support it, my client is calling everything into question when he pleads not guilty. He's calling everything into question as to, particularly, I think, the co-defendants, because they testified it was my guy. Ray was the one who was there, who was a shooter. My client saying, I was home. Was
there ever any evidence that specifically contradicted the idea that Hicks went inside, bought cigars, and was wearing a sweatshirt and hoodie?
I don't think there was evidence specifically toward that point. I think just generally speaking, my client was challenging everything the state was arguing with his claim of innocence. And that's why I think it is not uncontroverted. It may be supported by other evidence, video evidence, but I don't think that just in itself makes it uncontroverted. So I think it still was an issue at trial. And certainly the co-defendant's testimony fingering my client was an important part of the state's case. And when they get up in closing argument and start saying, we know they did A, B, and C, in effect, the state is kind of vouching for their testimony. Now, certainly it points to other evidence to support that, but I think when you start going into that and saying, we know they did this, it lends credence to their testimony, which in turn, the flip side of the coin is it hurts my client's defense. So we believe it was error in that instance as well. With the time remaining, I would like to touch on the second issue, which is display of the gruesome pictures in this case. There were multiple autopsy pictures, multiple scene pictures that were admitted without objection. However, during the display of one of the pictures, there was an objection to the extended time period where it was displayed to the jury. And I think that when you look at the probative value of this evidence, which we would argue was limited, given that the question of the day was who did this as opposed to what happened, the extended display of the pictures of the deceased at the scene was overly prejudicial. The district court, when defense counsel objected, saying that this was overly prejudicial for leaving it up for an extended period of time, the district court essentially said, well, that's a pretrial issue, and didn't do anything to mitigate it. We believe that that was an error.
I understand that you made no objection and you don't pursue a claim on appeal that the photos were inadmissible for any reason.
That's correct.
Your only claim is that they were displayed for too long.
Correct.
Is there any case that suggests that the length of time that admissible evidence is in front of the jury can create any kind of prejudice or error?
Admittedly, I did not find one, Your Honor.
I mean, it seems
If I did,
counterintuitive. If it's admissible, why can't the jury look at it for as long as they want?
I think that there is a point where it becomes overly prejudicial just to put it in front of the jury's faces for an extended period of time, even if it is an admitted exhibit. Because again, you have to look at the probative value and prejudicial impact and why or what would be the purpose of just showing this picture forever.
But wasn't that analysis already done when the pictures were admitted into evidence? Is the probative versus prejudicial some sort of ongoing test that lasts forever throughout the trial?
I think depending on how, and this probably goes for the defense too, how the state uses an exhibit can raise those issues. And here, I think the extended display of this picture in front of the jury was overly prejudicial. Again, the question wasn't what happened. No, I mean, this was blood splatter evidence. Frankly, I don't know what the point of that testimony was in total, because nobody was contesting that. So it has limited probative value, but it is a gruesome picture. It shows a young kid who was shot and killed. And jury, we may see this stuff pretty frequently. Juries don't. And as defense counsel noted, he saw the jury's faces when they were looking at these pictures and the impact that they had. So the extended display can become overly prejudicial such that the district court should have taken action.
When you talk about display, I cut.
Go ahead.
When you talk about display, just help me. We have different courthouses across this state. What was the display? Was it a screen? Was it publishing photos to the jury where they hand them around? We have a great variety of how they're displayed. How was it here? And maybe Mr. Cowton would know that also. I'm just curious more.
Yeah, and he may know better than I. My understanding was it was displayed on a screen.
On any screen?
I don't know if there's more than one.
Okay, I just want to.
My understanding is
understand what
would-
visual kind of
Sure.
impact this would have on a jury or a juror who's sitting 10 feet away. It's right in front of their face. I'm curious of how that.
My understanding is that they have large screens that they project images on in Johnson County.
Okay.
That's what was done here.
Well, sounds to me like, I don't know, maybe this is an extension of Justice Stiegel's questions, but it doesn't strike me as well suited for our evidentiary frameworks to assess this argument. Is it better suited as a prosecutorial error claim?
Maybe. I raised this as an evidentiary issue.
Right.
Kind of, because it's actually the use of the evidence. And the objection at trial was that specifically, this has been displayed for an extended period of time. It's overly prejudicial and has a pretty big impact on the jury. And that's how we've argued it on.
And yet the jury would have had it in the jury room, and we have no idea how long they might have looked at exhibits or how the exhibits might have been used there.
I think specifically with this one, if my memory is correct, it was a demonstrative exhibit, and I don't know that it was sent back. But I think there was other similar pictures that would have been admitted and went back with the jury. But I think the one on display when the objection was made, I believe, was the demonstrative only.
All right.
But if the others were similar and they went back in the jury room, where's the prejudice?
I think there still is prejudice from displaying it in front of the jury for an extended period of time, given the impact it would have. And it would push the jury to look at this as a terrible crime, and someone needs to be punished. And that pushes them away from looking at the issue at this case, which is who was the second person in the apartment. Thank you.
Thank you.
May it please the court, Kendall Kaut for the state of Kansas. I'll start with issue 1, but I definitely want to make sure I answer the question you had, Chief Justice Lukert and Justice Rosen, that you had once we get to issue 2. So I'll make sure to address those, but I'll start in the order that was brought up by the defense in this case. We would certainly agree there are 4 instances or paragraphs of we know. We've conceded one of those we know instances under the more recent framework from this court would be error. And so we turn to that second step of the prosecutorial error analysis in our post-Sherman framework. The first one, I think clearly though, meets what is allowed under we know in that wide latitude that a prosecutor is allowed. The evidence is uncontroverted that Alan Michael Hicks went to 7-Eleven and that he was also at the Quick Shop. There is a video of Mr. Hicks at that Quick Shop. It's clearly his face. He's buying cigarillos. I think he hands some paper money over to the clerk who's working at the register that day, and he doesn't get change back. And we know it's him depositing that hoodie in that storm cell that's eventually recovered by Brianna Stewart. And there's that photo of her coming out where she's halfway up, which is a little bit unique in this case. But we know from that Ring camera footage that Mr. Hicks deposits that hoodie, and from the DNA analysis that shows it's in the octillions, that it's his DNA on that hoodie and that firearm that's deposited in that storm drain. I also think on the question of, well, what's uncontroverted evidence, yes or no? It'd be too broad just to say, well, the defendant challenges every element of the crime, therefore everything is controverted. Well, if that's the standard, then there would be no uncontroverted evidence, which would run afoul of recent precedent this court has had when assessing these we know statements. When we look at what happens in this case, then I think we turn to are questions in and of themselves, or at least the questions in these specific instances, evidence of prosecutorial error. And I think the test for how questions are viewed by this court post Alfaro Valea, the 2022 case where the state tried to say, can we get back some leeway on we know is within the wide latitude, and this court said, no, we're still going to hold you to we know can be prosecutorial error if it's not at least uncontroverted evidence, or if the state's trying to draw an inference from it, then we know is not appropriate. In this instance, I think it leads to what I would say is that sometimes the Sherman two-step analysis of what's within the wide latitude, then we shift to, is it harmless under the constitutional harmless standard, sometimes can get blurred a little bit. And so whether this court says, hey, in this instance, these we know statements are error because we feel these questions are just a little bit too broad or do require that reasonable inference or not, ultimately, I think it's still going to be harmless. And if the court wants to engage in a discussion about that, I'm happy to, for why we think it's within the wide latitude. We briefed on this issue. I think our best point would probably be there's a question. In that first instance, how do we know that it was Ray Cherry? Do we know that only because Mike Hicks and the driver told you that it was Ray Cherry? No. And then there's a statement there. And in that second one, why do we know that it was Ray Cherry? Because the driver told, or excuse me, because the fiance told you that it was Ray Cherry, she came into this courtroom, she started testifying. Whether the court feels that's error or not, ultimately it's going to be harmless under that second step of the Sherman analysis. And why I think it's clear that that is harmless is I have been unable to find any case where the use of "we know" by a prosecutor has not been held harmless by this court and by courts of appeals and those panels throughout Kansas. And in this instance, when we look at the evidence and we look at what's contested in the case, Mr. Harris, the defense counsel for Mr. Cherry, did not contest that his client's DNA was on that cigarillo that's left outside the apartment. The only argument against that is, well, he'd been smoking with them a few days earlier when the Chiefs had their first AFC championship game in the Mahomes era, and that's why he has his DNA on that cigarillo. Not a very compelling argument, though, when he at first told the detective, "I don't know these people," directly contradicting his statement, or why they would choose to smoke a cigarillo that is old and has been put in the ashtray 3 days before when the Chiefs would have played the Patriots in the Super Bowl, instead of using their brand new cigarillos, why they would go back to a cigarillo that somebody that's not with them has already smoked, why the fiance of the victim would say that's the shooter, why they would pinpoint someone else differently, and perhaps most importantly, why they would drive to a 7-Eleven that backs up to the apartment to the defendant. Why would they go to another gas station? Why would there be 2 gas stations on this journey in this case, unless they were picking up somebody that lives right behind the gas station, which is where Mr. Cherry lives? So all of that evidence coupled together is so overwhelming that it would be hard in this case to say that those just few "we know" statements are what moves the jury, and ultimately this court would be able to say beyond a reasonable doubt those brief statements did not impact that jury's verdict. Beyond that, this is a 7-day jury trial. And in some of the court's recent precedent, whether it be State v. King, whether it be the Brown decision, whether it be Alfaro Vallejo, there's been pointed out it's brief statements in a week-plus trial or in a long trial. It's hard to believe, with all the evidence presented, with all the testimony of witnesses, that what would decide the case for these jurors would be a few "we know" statements that are made in these paragraphs. So in that instance, that's why we believe, regardless of how the court comes out on the question of, is this "we know" statement just a little too afoul of the first step in the Sherman analysis? And we have our arguments for why not that I think we've presented with our briefing. But even if that's the case, to say this would be the first case in Kansas when the evidence is so overwhelming, the trial is so long, and additionally, what's been pointed out in cases like Alfaro Vallejo is when the jury is instructed for those pick instructions on things like, it is for you to determine the weight and credibility of the evidence. And when there's a mention that statements, arguments, and remarks of counsel are not evidence. Both of those instructions were given by Judge Draghi, and in State v. King, the 2018 case that this court ruled upon, that was held to be important in the analysis. You couple the importance of those pick instructions with Mr. Benefeld beginning his closing argument by even highlighting those instructions, and it would seem that satisfies any concern with harmlessness under this test.
It sounds like what you're saying is that there are cases out there, and we're pretty clear that "we know" is error, in certain cases, but that it will never be reversible.
Justice Standridge, I am saying in instances like this, it will not be. The example I could think of, Justice Standridge, would be if somebody stood up and said, "We know he's guilty because we have evidence you haven't seen." I think that'd be an instance where the "we know" is coupled and problematic. Or if the prosecutor would say, "We know he's guilty because I've looked at the files," or "We know he's guilty because we can really trust this witness and believe them for how stoic they were, and that's why you trust them," which would also run afoul under prosecutorial
Isn't
error.
that kind of what happened? It was controverted about the identity, and he said, "We know it was him." And so basically, isn't he vouching for the witnesses, what the witnesses said?
Justice Standridge, I don't believe he's vouching for the witnesses in closing, because I believe it is tied directly to the evidence as opposed to providing vouching that exists outside of the evidence. So I think it's the tie into, this is what they testified to, here's the substance of their testimony, that differentiates it and allows this court to say, if there were to be a line where "we know" becomes not harmless error or reversible error, it would be not tying it into the evidence in the case and providing some external validation that's not present.
But when you were arguing, you went through and said, basically what you're saying is that we know was justified because his version of the story was not credible.
Justice Standridge, I'm saying it's justified under harmlessness because it's not credible. I think under the first step, if the court said, hey, there's some vouching, or the question is at least an inference that that might run afoul under the post Alfaro Vallejo. So I think I'm more focused on that second step, and that would be the distinction I would hope the court would draw under this case. If there are no additional questions under that first issue, I'm happy to turn to the second issue related to the blood spatter analysis from the slide. Just to address at the top the two questions, I'll start with the one Chief Justice Lukert you had. This particular exhibit that was objected to by Mr. Harris was just the demonstrative PowerPoint, so that one would not have gone back to the jury. Justice Biles is correct that there was very similar evidence admitted that next day, and those would be States Exhibits 61A and 61B. So it appears to me from the reply brief that all Mr. Cherry is objecting to is slide 21 of that demonstrative Exhibit 59, which is the blood spatter PowerPoint that has gone over by Mr. Morris. If that's the case, 61A and 61B in the admitted exhibits are just a rotated version of showing the gunshot to the victim. So if there is some concern about prejudice, first, there is not a contemporaneous objection, which would be necessary, we know, under KSA 60-404. And second, it would still be presented to the jury. So if there's some risk of prejudice from showing it to them, as Chief Justice Lukert mentioned, they would have that back with them. And as Justice Biles mentioned, they'd have the opportunity to consider it back there and weigh that. To consider the question of Justice Rosen about how's the setup in Johnson County, or what are the screens like, the new courthouse opened in Johnson County in 2020 in December, moved our stuff over in the COVID era, had some nice people help us with that. And the way it works in Judge Dragi's courtroom and in our courtrooms that can hear criminal trials is that there is a podium you can go up to that has a screen. The witness testifying has a screen in front of them that's like a computer monitor you would have, or if you hook up a third external monitor to see things. And then each juror who's in the box has a screen in front of them that they can see. And those are situated in most courtrooms where there's one screen in between every two chairs to save a little bit of money, not having 14 screens, because most of our boxes can seat 14 plus people in case we have alternates in some of our bigger trials. So there generally would have been about 7 screens for the respective jurors to look upon. My guess is those are probably about 12 to 15 inch size monitors that they would have been able to see that day. There's also a high definition television that is behind the witness stand. From the record, it is unclear to me if that TV was turned on. My experience trying cases in Johnson County post the new courthouse, sometimes we turn those TVs on, sometimes we don't. That relates to maybe if there are family members in the gallery, we don't want to have them see their loved one on the screen, or maybe they don't want to see certain evidence, but we make sure it's available for the jurors. So I can't tell you in this case if that was presented to the whole courtroom on a giant screen, but they would have had it on monitors in front of them. Ultimately, regardless of what happens here, I believe the issue is waived by the admission of 61A and 61B the next day. Certainly agree with the line of questions presented by Justice Wall and Justice Stegall about objections under the probative versus prejudicial analysis that's set up by case law and is set up under federal rules of evidence this court's adopted for decades, would be that that objection cannot just be satisfied by saying it's been up too long.
So let me ask a little bit about that. You would agree that there was an objection at trial that these have been up too long?
Agreed, Justice Stegall.
And it's framed on appeal as kind of an evidentiary objection, which makes us think of weighing probative versus prejudice and all that. What if that's not really what the objection was? It wasn't an evidentiary objection per se. Could it have been? And I'm trying to think about, does a district court have the ability to just essentially control the courtroom where you have admitted evidence, but the defendant basically says, look, judge, that's been up for 2 days. Can't we take it down? Is that a reviewable? I mean, how would we review that kind of a request and ruling by a lower court?
Sure. So Justice Stegall, I do think a district court judge has the authority to manage their courtroom, run affairs. So I do think if Judge Draghi had said, you know, I'm tired of looking at this, or it's been up too long, he could order it taken down and the parties.
Right. The prosecutor does not have a right to keep a piece of evidence in front of the jury during the entire trial, right?
Agreed, Justice Steigel.
The district court has the authority to control the courtroom to that extent. And why shouldn't we look at this essentially under an abuse of discretion standard in that regard? Because it does seem to me as though a defense attorney can make a reasonable objection to, look, okay, so this evidence is admissible, but it's been up on this screen for 8 hours. It needs to come down. Isn't that a reasonable request? And I know that's not the facts here, but.
So Justice Steigel, hypothetically, I'm willing to entertain there could be some instance where that's a reasonable request. I think part of the reason why this probably doesn't come up on appeal much is normally if you're the prosecution, you may not want to put the image up there for 2, 3, 4 days because it might dehumanize your victim. The jury might get offended at you with, why are you just showing us this dead person for a while? But to answer the question specifically, if the court reviewed for abuse of discretion under this factual scenario, I think there is not enough of an objection that would be timely and note things. So
Well, why not? He said that the objection was clear. This has been up for too long. And if it's, and my question is kind of the legal question. If that's not strictly speaking an evidentiary objection, what kind of objection is it?
So Justice Steigel, I think it could be evidentiary. It could be abuse of discretion. As mentioned, since there is a case law that really goes into this, we're more 10,000 feet. However the court wants to view it, I think we feel comfortable under any standard. Ultimately, what the problem would be here and what I mentioned for why it's not specific enough is I think it's up to district court counsel to say, this image has been up for 45 minutes because I've seen jurors 1, 4, and 7 look perturbed by it. That's the reason why I'm asking it to go down. And then if the judge said, I agree with those factual findings, but I believe that the jury has a right to see this for 4 days if it would like to, then the court could review under its 3 prongs for abuse of discretion, whether there is an abuse of discretion there.
You're out of time, but real quickly, I wanted to talk briefly about the jury trial waiver. Do you agree that there was no jury trial waiver?
Agreed, Justice Steigel.
And you would just hang your hat on the fact that even if essentially harmlessness, that the defendant received the benefit of the bargain and would have waived his jury trial right?
That is the entirety of our argument on that. You're correct, Justice Steigel.
Thank you.
And if there are no additional questions, I can see I'm out of time, and I would just ask this court to affirm the ruling of the district court and the jury's finding of guilt on all counts. Thank you.
Thank you. Mr. Meharry, you reserve 3 minutes.
Unless there are questions, I would waive rebuttal and ask that this court reverse this matter for a new trial.
Do you have any disagreement with the stipulation issue? What is your prejudice argument on that issue?
I think the state has to show it was harm. And we don't have anything in the record. There is really no discussion about it that would support the state being able to say, had he been advised, he would have done this. It's the state's burden to show that, and they don't have anything they can point to support their argument otherwise. And I think in the brief, I've detailed a few cases out of the Court of Appeals where they talk about what you can look at, and they talk about it's harmless in this case because there is this discussion on the record between the attorney, the district court, the defendant, etc. And we don't have any of that here. So I don't think they can meet their burden of showing that this was harmless. Thank you.
Thank you. And thank you to both counsel for your arguments today. The court will take this matter under advisement